Good morning. On behalf of myself, Judge Reardon, and Judge Young, welcome to our case call panel. We see some familiar names on our call today, and we understand that these cases are important to the litigants and counsel, and they are important to us as well. I assure you we've been diligently working on these matters. We've had the benefit of your excellent briefing, as well as the work of our research division and chambers. We're familiar with the relevant facts and pertinent law, and we ask that you focus on your most salient points. Finally, we're hearing matters involving sexual assault victims, personal protection orders, and children. Because these proceedings are recorded, we ask you to please substitute initials in lieu of a victim's, petitioner's, respondent's, or minor's full name in those cases. With that, we look forward to hearing your arguments. We ask you to keep your own time, but I'll also be assisting you in that regard. So I'm going to call our first case of the day. It's number 14-369-653, People v. Rivers. And that case, we had a... Are you coming up for this one? Oh, no, it's fine. It's fine.
Didn't you ask to wait or reschedule or? Yeah, we were granting that. Yeah. Yeah, we were granting 15 or 14 and 15.
You can try.
Yeah, sorry about the mix-up. Yeah. Yeah. Well, what we are granting is we're waiving oral argument. We don't necessarily think you need oral argument on this, which on both.
On both.
Which hopefully you agree with. Okay.
And in the interest of fairness, it's for the next one where there is opposing counsel, that oral argument is waived as well. So the whole, yeah.
Yeah, we're sorry that you didn't get those orders in a timely fashion. It was difficult though, especially the one that we got yesterday was quite late. Okay. All right, so that case will be submitted on the brief.
Good luck and don't drive too fast. We'd hate to have you as a defendant in here. All right.
So that case is
I guess you could represent yourself. You'd be good. Yeah. All right. Take care.
Sorry for your loss. Yeah.
Thank you. Okay, that case is submitted. So we're calling number 15-374-915, People v. Watkins. And we are going to be issuing an order today, dismissing oral arguments and making an order, and deciding these matters on the brief. So thank you very much. Okay. Thank you very much for coming. All right. The next one is number 16. Those two were submitted, 373-610, People v. Clark.
Good morning, Your Honors. May it please this honorable court, Alona Sharon on behalf of the appellant Dennis Clark. I will reserve 3 minutes for rebuttal, although I don't think I'll be up here for a particularly long time. There's obviously 3 issues in the brief. I do just want to touch on the first one, despite the fact that the parties seem to agree that Mr. Clark is entitled to a resentencing. I do just want to clarify, because when I was reviewing the prosecution's brief, I was left a little bit concerned that the remedy ordered by the court might just be for a remand for rearticulation, but I do believe it should be that the sentence is vacated and a full resentencing ordered. I think there is a very serious question from the record whether or not this judge understood that the court was imposing an upward departure sentence, because
I think you might be in good shape, but you can keep arguing.
No, that's fine. That was just the one thing I wasn't sure if it was. I think it was clear in my brief. I just wasn't sure if the parties were on the same page as to that point, so I just wanted to address that before the
I
court.
thought they were. so,
Okay,
yeah.
thank you, Your Honor. Your Honor, I have seen you more in the last 4 months
You
than I
know-
have seen my own husband, by the way.
Wait a minute.
Gonna start some rumors here.
I'm just teasing.
I got a tough, well, my wife is very nice, but she'd be very angry.
But thank you, Your Honor. As to the remaining 2 issues, I am comfortable relying on the brief. I do think the case law is fully addressed and the facts are addressed as well. So unless the court has any questions as to those 2 remaining issues, I'll just wait and see if I have anything to say on rebuttal.
No, you always do a great job.
Thank you, Judge.
Thank you. Good morning.
Jennifer Bredeman on behalf of Lenawee County Prosecutor's Office. I suppose in light of what counsel just indicated, I don't really have anything too extensive to add than what's in my brief. I think I laid it all out in terms of factual arguments as well as legal arguments. And I think that in light of the record, that both of those issues should in a sense, be denied by this court in terms of that the evidence, the 768.27A evidence should have come in, that was not abuse of discretion, and that there was no ineffective assistance of counsel as far as vouching, because there was no vouching. So, but I am happy to answer any questions as well.
I have nothing.
Nope, thank you very much.
you.
Thank you very much.
How do you rebut that? All right, have a
Thank you.
good day. Stay cool.
Okay, that case is submitted. So we move on to number 17-375-692, Affiliated Diagnostic of Oakland versus Auto Club Insurance Association. We have one person for oral argument today, endorsed.
Morning, Michael Ferguson from the appellant.
Do you appear in case we have questions, sir? Okay.
Can we grant that?
I also have another case right after this.
I don't think we granted that, so it's
It's up to me, right? Isn't that what the new rule is?
yes, yeah.
Yeah, all right, I'll allow him
Okay.
to stay for questions. There's a new court rule that you have to have the permission of the presiding judge to appear for questions when you're not endorsed for oral argument. So I will grant that.
Good morning, Your Honors. Brandon Wyckoff appearing on behalf of the appellee.
Okay.
To begin, I'm not going to defend the trial court's reliance on MCR 2.207 because this court held in 2021 in the Michigan Head and Spine case that provider plaintiffs can aggregate claims of the multiple patients in a single case. Otherwise, there was a basis for the trial court to dismiss the case under MCR 2.504B1, which authorizes the court on a motion of a party or sua sponte to dismiss a case for violation of the court rules. On reply, plaintiff relies on the Shell versus Baker Furniture case to argue that 2.504 does not authorize the trial court to do what it did sua sponte. But that case was decided in 1998. And when you look at the staff comment to when that rule was amended in 2008, it clarifies that the rule was amended to allow trial courts to sua sponte dismiss a case for violation of the court rules. And so the current rule uses the term sua sponte, and so there's no question that 2.504 allows the trial court to do what it did in this case. Finally, plaintiff argues that the 7 Dean factors weigh in favor of dismissal. I've never seen a decision apply those Dean factors outside the realm of a violation of a discovery order, or if the trial court dismisses an expert witness, which is tantamount to dismissal. So I don't think that the court should apply those 7 factors rigidly to this case. I think maybe a few of them would apply here. Otherwise,
So you want them to apply them in a relaxed manner?
yes, Your Honor.
Okay, whatever that means.
Right.
Okay.
Lastly, if the court finds that Judge Elder abused her discretion, my alternative argument, of course, is that her order should be affirmed on a right result, wrong reason rationale. This was set up as a motion for summary disposition based on the fact that defendant paid each and every one of plaintiff's claims based on the maximum amounts allowed under MCL 500-3157-2, which
Difficulty with that is FEVO came out after and the math of it all wasn't addressed. I mean, none of your summary disposition was addressed by the trial court.
I understand, yeah.
Yeah, so I don't know, it feels sort of artificial to contemplate right result, wrong reason on such a heady issue that involves, you know,
Right.
the applications, Medicare rules and percentages off and things like that.
Also a pretty severe sanction.
Understood, Your Honor. Unless the court has any other questions, I'm all set.
You.
All right, thank you.
Any questions for counsel? We have no questions for you, sir. So we are going to submit that case. And
You
call.
stay at the same place. so-
Yeah.
We thank
You're
you.
welcome. The next case is 18. It's 374-992. And Mr. Fergstrom, you are endorsed for oral arguments, and we have several others. I'm sorry? They did check in, yes.
And who was that? Sir? You better hurry up.
Yeah, it's never fun when you get called as you walked in. Good morning.
Good morning, Your Honors. Michael Fergstrom for the appellants.
Would you like to save some time for rebuttal, sir?
I would, Your Honor.
How much would you like?
3 minutes should be fine.
Got it. Thank you. You may start.
Your Honors, litigation is an adversarial process. Even so, it has been my experience that the no-fault bar is a remarkably collegial one, primarily because the same attorneys see each other all the time, certainly much more collegial than when I did commercial litigation for most of my career. This case was an exception. There are a number of allegations of outright lying by the appellee's counsel. I think the one clearly untrue statement in the course of this matter was when the defendant in the trial court asserted in its motion papers that it had been seeking these depositions throughout the pendency of this case. It's a 2023 case, as the court knows from the recitation of facts. We took this case over from the late Mr. Pritchard when it was significantly in arrears in discovery. Less than 2 weeks after we appeared in the case, we filed initial disclosures and answered written discovery in which we identified the witnesses that are at issue here. The defendant in late July of 2024 noticed the depositions of 3 of the witnesses to take place in September, and then the very next day filed a motion to compel the depositions. After that, there was I don't know, perhaps a comedy of errors. The 3 witnesses had their personal attorney who was trying to arrange for the depositions, as he indicated in his affidavit, which was filed in the trial court.
I'm going to interrupt for a second. Did you file an extension from that 30-day order from the trial court?
He did not, Your Honor.
Why not?
At the time, once we received the notice of deposition, we immediately contacted the opponent's personal counsel, who, to our understanding, was attempting to schedule the depositions and did propose dates that were outside the 30-day period, but by only a matter of a week or two to accommodate scheduling.
Your argument that by scratching all 3 experts, that was in effect a dismissal of?
Well, it ultimately turned out that way, Your Honor. The 3 witnesses were actually party witnesses. 2 of the doctors from Multicare and a gentleman who had some administrative role in the other plaintiff. All of this took place over a period from late July into September.
Is there anything on the record or off the record that happened in bench conference or something that's not reflected that the trial court considered lesser sanctions besides there was there's no oral argument on that.
And we don't have anything in our records that.
No,
would-
there was an oral argument scheduled for September 18th on the motion to dismiss or strike the witnesses. We filed a response which included the affidavit of Mr. Ewald. 2 days before that, the court said that it was dispensing with oral argument and issued the order striking the witnesses.
No, nothing in the order contemplates lesser sanctions than that striking.
No, Your Honor.
And then there was a summary disposition motion, but my understanding is that you didn't go to that.
Well, we responded, well, I'll refer to the comedy of errors again. That morning, Judge Brennan had a rather large docket. I had a motion in another court. I appeared for the other motion, which is, it's common for people to appear after the scheduled time. I think I was perhaps 15 or 20 minutes after 8:30 when I attempted to get in and found, when I ultimately got in, Judge Brennan told me that she had called the case at 8:30 and that she had, because I was not there, she decided that she would rule on it without oral argument. So yes, I was not there when the case was called. I was actually in another Zoom hearing in another courtroom at the time, and shortly thereafter.
You were remote? You weren't in the courthouse itself,
No,
is
it
that
was-
correct?
It was remote, Your Honor. Now, the striking of the witnesses is a matter of abuse of discretion. However, a case law does say that when the sanction is a very severe one, the court should very carefully weigh its options. That's noted in the DeRay case, which says that striking witnesses is, in fact, a very drastic and severe sanction. And the Kalamazoo oil case, of course, says that there's shown to me there should only be such a severe sanction if there is a flagrant and effectively willful refusal to facilitate discovery. In this case, we answered the written discovery almost as soon as we took over the case from the late Mr. Pritchard. The deposition issue arose shortly thereafter, and as the record shows, and I think the affidavit of Mr. Ewald shows, at all times, we and the deponent's counsel were working to schedule these depositions. There was never any time when there was any suggestion that we would not provide the depositions. As far as the trial court made a ruling that we had made no attempt to cure the defect, that our refusal to cooperate with the depositions appeared to be willful and intentional. It clearly was not. And then when we get to the summary disposition motion, after the witnesses were stricken and after our motion for reconsideration was denied on that issue, the motion for summary disposition argued that without those three witnesses, we could not make a case. We pointed out in our response to the motion for summary disposition that there were a number of other witnesses on the witness list from the parties, that we had identified a number of other witnesses in the initial disclosures and the written discovery, and had also provided all of the relevant documents and records, and that although we wanted those witnesses reinstated, that we had other avenues to make the case at trial. The trial court then issued an order granting the summary disposition motion on the ground that we had not produced evidence that the treatment was reasonably necessary. An argument that was not made in the motion for summary disposition. So no, we did not respond to that motion, to that issue, or provide evidence on that issue because it wasn't in the motion for summary disposition. We responded to the issue of whether we could make the case without those three witnesses, because that was the entire basis of the motion for summary disposition. think if you look at the record of this case overall and the very short time frame between when we came into the case, when the depositions were noticed, and the efforts by us and by the deponent's counsel, Mr. Ewald, to schedule the depositions, asking for perhaps a week delay to accommodate schedules, and instead we got a blizzard of motion to compel the very day after the notices went out, a motion to strike the witnesses or dismiss, a motion for summary disposition, all of which happened in a very short time period when we were clearly trying to schedule the depositions. This was certainly not a case where there was any willful or wanton failure to provide discovery or failure to cooperate in discovery. The case admittedly was a mess when we took it over. The late Mr. Pritchard had a number of cases that we took over, all of which were in some level of dire straits because he was in his late 80s. He was not attending to the cases.
I think it would have helped for argument today to have filed a motion to extend rather than let the deadline pass for when depositions.
In hindsight, yes. At the time, because this is something that happens constantly in this practice, where you have to schedule depositions of medical professionals, and they often have their own counsel. And frankly, not an issue in which we normally see what I call the level of litigation aggression that we saw in this case. Even then, we did point out to the trial court that we are and were at all times trying to schedule the depositions of these witnesses. Mr. Ewald, who submitted an affidavit that was attached to our response on the motion to dismiss or strike the witnesses, planned to appear at the oral argument on September 18th, which never happened because the trial court decided to make a ruling without the oral argument. So yes, in hindsight, could we have done other things? Yes. I mean, I've never seen a case in which I couldn't have done other things, but in this case, we really did not foresee this series of events that happened because it's something that was really, and as I've said in my research, somewhat unprecedented in my more than 30 years as a litigator, to have someone file a motion to compel the very day after they filed the notices of deposition, and at the earliest possible opportunity file every possible motion to have the case torpedoed. I don't fault opposing counsel for doing their job. This case, as I said, turned out to be a very unusual one in my experience in this bar, because what should have been and usually would be a routine matter of rescheduling depositions cooperatively and accommodating people's schedules turned into the situation that we're in now. Obviously, the motion for summary disposition is to be reviewed de novo. I think the principal issue there, as I've said, is the fact that it seemed it was granted on an issue that was not even part of the motion for summary disposition. Certainly, I don't think it was fair for that to happen. If that issue had been raised in the motion, we would have responded to it. We didn't respond to it, as the trial court said, but we didn't respond to it because it simply wasn't there. If the court has any questions beyond what you've already asked me, I will certainly try to answer them. If not, I will preserve a little time for rebuttal.
No questions here. You have time for rebuttal and you may be seated.
Thank you.
May it please the court, David Kinzer on behalf of defendant Appali Progressive. So this is a case about whether a trial court judge has discretion to sanction a litigant for numerous failures to produce requested witnesses and for violating a court order to produce those witnesses. When discovery closed, with plaintiffs having defied that court order, having never produced any of its witnesses, there needed to be consequences, and the court's choice of sanction to strike the witnesses that had been withheld by plaintiffs was well within the court's discretion. Plaintiffs appeal.
The court's supposed to consider lesser sanctions, because the difficulty with that is, at first glance, it appears the striking of witnesses is a lesser sanction than dismissal, but then you file a motion for summary disposition and say, in fact, it's not, and win that motion for summary dismissal. And so if the striking of those 3 witnesses was in effect a dismissal, which you successfully argued it was, then the trial court was supposed to consider lesser sanctions and did not.
I completely agree that the court is required to consider other alternatives. And in this case, the court did. First, regarding the motion to dismiss or the motion to strike, plaintiff did not mention that their response was filed the day before the hearing, which is also the day that oral arguments were canceled for the hearing. When the court considered our motion, they did not have plaintiff's response, and they were not required to consider improperly filed responses. Nevertheless,
How was it improperly filed?
it was filed the day before the hearing.
Is that late or something if that happens, or?
Yes, Your Honor.
But I don't think you answered Judge's question, and I was waiting for it.
Mhm.
Like, can you point us to some place in the record that we currently have before this court where the lower court considered a sanction that was less than striking these witnesses, which ended up being the equivalent of a dismissal?
Yes, Your Honor. In the order that was issued by the court, it goes through the factors from Dean versus Tucker, considering that the failure to produce the witnesses was willful and not accidental, that there was a history of failing to comply with discovery requests, that Progressive had been prejudiced by withholding all of plaintiff's witnesses for the course of discovery, that there was a history of deliberate delay, and that plaintiffs had generally not complied with the court rules and court orders, and that there were no attempts to cure, and that the no lesser sanction was appropriate.
What lesser sanctions did the court consider? That's our question.
Mhm.
Am I correct? Yeah.
I believe the court concluded that based on the factors from Dean versus Tucker, that no lesser sanction was appropriate. I do not
Did she
believe that
articulate that on the record?
she did not articulate the different factors that she considered, but she did articulate that no lesser sanction was appropriate. And it is my understanding that that is appropriate under the court rules, that that the judge must consider lesser sanctions, but it is not necessary that the judge name the lesser sanctions that were considered. And of course, if the response was properly filed and the judge was able to consider it, that lesser sanctions would have been able to be discussed. Later on, of course, plaintiff filed a motion for reconsideration, which the court did have an opportunity to consider and further discussed whether lesser sanctions were appropriate. and again found that they were not appropriate. That the court did consider this issue thoroughly, despite the fact that it appeared to be unopposed when initially filed. Another matter that I would like to discuss, the most crucial fact that plaintiffs leave out of their argument, which is that discovery was set to close on September 5th. I don't believe that plaintiff's appeal brief discusses this at all. And when you don't know that discovery closed in early September after 2 previous adjournments and delays, you don't know why Progressive was so set on having these depositions in July or August when it still had time to submit discovery requests based on the witness's testimony. It goes without saying that defendants are entitled to investigate the evidence proffered by plaintiffs, and that by pushing the depositions back and back, Progressive was prejudiced as its ability to prepare a defense was undermined. Plaintiff's brief presents the court's order striking its witnesses as an inordinate punishment for a one-time mistake, a routine scheduling conflict, that it wasn't even their fault. It was the fault of this other attorney. Sanctions for someone else's one-time mistake do not seem appropriate. But the trial court knew that that wasn't accurate. It wasn't a one-time mistake. It started with plaintiff's failure to provide the initial disclosures, which they did.
Matter that was a different attorney or no?
It was, we had to compel the initial disclosures when it was the current counsel. And they were still not provided until there was a court order, even facing the motion to
My
compel.
understanding is that there was a stipulation between the parties for the late filed disclosures. So I don't understand how you can have it both ways, where you stipulate to a later filing, but then also weaponize the late filing against the opposing party. So was it a stipulation by you to allow a late filing of a disclosure?
Yes, Your Honor, you're correct. It was with the motion to compel the initial disclosures, where
Same late filing that you're now saying was problematic that you stipulated to.
well, that's just the opening, right? After that, once we consider the initial disclosures, we request these depositions. We request them on July 5th, July 12th, July 17th, without receiving even a proposed date from plaintiffs. Then we file the motion to compel on July 25th. Plaintiffs present that as there were no previous requests.
My reading of the record is you have about 2 weeks of emails to set dates without any notices filed. And under the court rules, it's your responsibility to file the notice. No notice is filed. You try to schedule dates without notices filed. And then once you file the notices, a day later, you file a motion to compel. So while there's some evidence that the 2 weeks of attempted scheduling didn't work out, that's also 2 weeks of attempted scheduling where no notices were filed. So how would those 2 weeks of attempted scheduling without notices be held against opposing counsel?
Well, it is my understanding that it is appropriate for the trial court to consider the circumstances surrounding the delay. In this case, the fact that Progressive had been attempting to schedule them and was attempting to schedule them before it produced a notice with an arbitrary date.
They could have not replied at all.
That's
There were
correct.
no notices.
And
But they did reply, and they did multiple times try to make a schedule. It didn't work out, but this was all before you even filed your notices. But now that same block of emails is being used as evidence of malfeasance in some way by opposing counsel, even though no notices were filed.
I would You know, there's a phrase, to deliberately waste somebody's time, to delay them going back and forth, and then to lose track of the conversation. And whether or not it was intentional delay or not in this case, at that point, what matters is that the depositions weren't scheduled, and on September 5th, discovery was set to close.
So,
Um,
I want to go back because to my question earlier, because I was able to pull up the order regarding the motion for reconsideration. Do you happen to have that with you today or no?
Not on me, Your Honor.
I don't see any um reasoning in here that would compare like a fine or any kind of mention of a lesser sanction other than dismissal that would be appropriate here. I don't think I have any argument with you about a sanction being appropriate, right? But I do have dismissal is supposed to be like the only, the last resort. It's like the most severe sanction. It's, you're punishing the litigant for what might not be in the litigant's control in any way, shape, or form. It's the attorney's action at this point. So that's why it's so important that the court provide for our review here that they did some kind of real weighing of these other possible sanctions before they came to the determination that dismissal was appropriate. I don't see it in where you pointed me to, which was the motion for reconsideration. Do you think maybe it's somewhere else that you could help me find?
Um, um, if I have the opportunity to review the briefs and supplement my argument, I would.
I don't know if we'll need a supplement. I think
Okay.
we're pretty well set.
Okay.
We're plowing the same territory over and over, same ground.
So I guess the question that it boils down to then is whether the judge is required to specifically enumerate the lesser sanctions that were considered. And
I don't know about enumeration, but there's got to be some indication.
besides the trial court saying that it did that.
What did she consider?
Exactly. And my remaining time, I would just like to address the motion for summary disposition that was granted, and plaintiff's counsel tries to argue both that summary disposition was not required and that it was a necessary result of striking the witnesses. And it's not my understanding of the record that that is true. Plaintiffs were still able to respond to our motion for summary disposition with evidence, specifically a affidavit from a non-stricken witness attesting to some of the elements that were required to be shown, and that plaintiff's counsel did not do that, and therefore summary disposition was required because of the response to the motion for summary disposition. And do you have any other questions? I certainly don't want to.
Just going back where
Of course.
the judge articulated that there were no lesser sanctions. What order did she do that in?
In the order,
Is that the September 17th one?
in the order striking the witnesses, which I believe is September 17th.
Okay.
Goes through why the court thought the sanction was appropriate.
She writes, when considering an appropriate sanction, considers Dean. Okay. All right, thank you.
There are no further questions. I rest on our response.
Thank you very
Thank you.
much.
Your Honors, we're again hearing about numerous failures, deliberate delay. Simple fact is, these depositions were noticed for September 3rd and 4th. The opponent's counsel tried to reschedule them for the 11th, apparently due to some miscommunication with the defendant's counsel. There were no notices issued for the 11th, and the defendant's counsel then offered September 18th as a possibility. So we're talking about a delay of a week or two in a case that admittedly was something of a mess, but to the extent that the trial court held the failures while it was in the hand of Mr. Pritchard against us and our clients, I think that really just doesn't work very well. As the panel has noted, as soon as we got the case and it appeared on May 27th, we almost immediately entered into a stipulated order for the initial disclosures and the written discovery, and we submitted those 13 days later on June 9th. So there's certainly no deliberate delay there. In terms of the depositions, again, we had an order striking the witnesses on September 7th, which was just a few days after they were originally noticed for in the depositions. As far as the summary disposition motion, again, it was granted, according to the record, on an issue that was not raised by the defendant and therefore not briefed by my office. And
So
finally,
what's appealed from? It's the motion for, or it's the summary disposition motion?
well, that is the final order.
Right. And so if we can we as a court reach even further back to that, striking of the witnesses, even though the final order before us is the summary disposition?
Yes, we made it clear we're appealing both orders, and the standard rule has always been that appealing from the final order implicates everything that happened previously. And I'll finish with the issue of lesser sanctions. Although there is what I'll call a very perfunctory reference to why this sanction, this severe sanction, is appropriate, there was absolutely nothing in the record to show that the trial court considered any specific lesser sanction. And if any sanction was warranted here, I believe it would have been something far less than striking 3 key witnesses and then from that ultimately granting summary disposition over the entire case. Obviously, I believe that the order striking the witnesses should be reversed. I certainly believe that the order granting summary disposition should be reversed for the reasons stated in my brief. If there are any additional questions, I will do my best to answer them. Otherwise, thank the panel for its time.
Any questions? No, thank you very much.
Thank you, Your Honor.
This case is submitted. All right, we're moving on to number 19, Lester Carroll versus City of Taylor.
Good morning, Your Honors. Amanda Waskey on behalf of Respondent Appellant City of Taylor.
See you, Ms. Waskey.
It is always a pleasure to see you, Judge. How are
Welcome
you?
back to the court.
I know, it's always good to be back.
It's another former law clerk.
Yes,
Welcome.
it's been a while. I've had quite the career after, but it always feels like coming home.
Career and a couple kids, right?
A career and a couple kids,
Yeah.
yes.
Would you like to reserve some time?
I
for
would
rebuttal?
like to reserve probably about 5 minutes for rebuttal.
Okay,
And given that the briefing in this case has been extensive and thorough, it is my intention to be brief in my argument. This case is about petitioner's request for a use variance to allow the keeping of backyard chickens on property that is zoned to be residential as emotional support animals. Mr. Carroll already has other emotional support animals that fit within zoning ordinance 1409. He has a combination of dogs, cats, and birds. The zoning ordinance does allow 3 dogs, cats, or birds. So he's already in excess of the ordinance by having a combination of those animals in excess of what's allowed by the ordinance. He also wishes to maintain a flock of chickens as emotional support animals.
Didn't he have a couple of letters? from
He
the
did. He had a
board?
couple of letters from, I believe, doctors who are his treating physicians.
Henry Ford doctors or something.
Henry Ford doctors, I believe a psychiatrist and a neurologist, who had diagnosed Mr. Carroll with Huntington's disease, which by all accounts is a horrific and devastating disease. And I don't think that anybody from the city would contest that it's truly a death sentence, and it is horrific to live with. And I'm sure to be a caretaker for Mr. Carroll as well. And I don't think that there's any dispute that Mr. Carroll would probably benefit from having some emotional support animals on his property. The issue is whether or not the chickens should be allowed to stay.
Even, I think one of the letters said even removal of one chicken would have a negative impact because I don't know a lot about chickens. We didn't have many on the northwest side of Detroit when I was growing up, but even the removal of one, I think there were 13 chickens or 11 chickens.
I think at some point there were in excess of 11. I'm not sure how many there are now. It's my understanding that some of the chickens that were there when the request was initially made are no longer on the property. I'm not sure if they've been replaced. I think the number last time Mr. Speck and I spoke was down to 8 chickens. Today, I don't know if that's still inaccurate.
No, I don't know how accurate the letter is saying that the removal of even one chicken would have an adverse effect on, impact on the plaintiff, for the appellee. But isn't it something that the zoning board should actually consider, those letters? mean,
I
at least-
agree.
I'm sorry, at least articulate.
Well, I will say, I raised this in the trial court as well. I don't think this is a situation where those letters were not considered at all. I think that the
It'd be
zoning,
nice to know, it'd be nice for us to know that they were considered.
and I think if you look at the zoning board minutes itself, which, I represent a lot of municipalities, and I've had quite a few zoning board appeals, and I will say that the explanation given in these minutes is more extensive than what we normally see when a use variance is denied. Here, they go through and they list several reasons why it was denied. They had some issues with the medical letters. They did not find that they had medical license numbers from the professionals. And I think one of them was actually unsigned.
Right, there was something,
There's some issues with it. And I think that the fact that that is explicitly noted in the meeting minutes shows that those letters were not considered. It went more towards the weight that the zoning board gave those letters. And I think that that really comes down to what the root of this appeal is that when you have an appeal to a circuit court from a zoning board decision, there's a very well laid out standard of review in the court rules and the case law. And it's very clear that if there's material, competent, substantial evidence to support the ZBA's decision, the circuit court has to affirm. It cannot draw its own conclusions. And I think what happened here is that the trial court didn't like what the zoning board did, and so undertook a de novo standard of review, which is not what is prescribed by the court rules and by the case law. And so in disagreeing, they completely reversed the ZBA's decision. The ZBA minutes in the city's perspective clearly show that it considered the request and it considered the evidence that was presented by Mr. Carroll through his counsel and found it to be unpersuasive. And so based on all that, the ZBA determined that Mr. Carroll had not met his burden. And under the law, it is his burden of showing why a use variance was reasonable or necessary. They also found, based on these meeting minutes, that the evidence presented was not sufficient to establish how using the property as currently zoned would create a hardship, especially when there are already emotional support animals on the property that fit within the zoning ordinance. I think the timing is also suspect. These chickens have been on the property for a very long time, even before Mr. Carroll's diagnosis. He was issued a misdemeanor ticket and a civil infraction, I believe 18 months before he even applied for a zoning variance. And I think that that begs the conclusion that perhaps this is a situation where we're asking for forgiveness and not necessarily permission. I don't think that sits well with the zoning board, especially when you're not asking for one chicken or two chickens. It's a whole flock of chickens. It's not a situation where Mr. Carroll has gone and done therapy and is like, wow, I really benefit from these chickens. These have brought me great comfort. I would like to bring this onto my property and have them at home. These chickens were already there and already well established. There's also notes in the ZBA minutes that there's a lack of information regarding the keeping and the health of the chickens on the property. And I note in our reply brief on appeal that in municipalities that do allow the keeping of backyard chickens, there are very strict health and keeping regulations that are articulated in those zoning ordinances, and they follow very closely guidelines issued by the Michigan Department of Agriculture. I know Michigan State University is mentioned, I believe, in the Huntington Woods zoning ordinances. And I think that that information is just not in this record, and it is the petitioner's burden to create the record before the ZBA. I guess the last thing I would highlight in that respect is that applying for a use variance does not necessarily entitle or guarantee that it's going to be granted. And denying that variance, especially when there are reasons articulated in the meeting minutes that show that the evidence was considered, not liking the result does not necessarily amount to an abuse of discretion.
Point me to where in the meeting minutes or elsewhere in the record, it sufficiently establishes whether petitioner's request was reasonable or necessary.
Yeah, I think that they, my notes state that they just simply thought it was vague, and support for that was the lack of the letters being signed or having a medical license number on them,
Right.
which is, I don't know, it's odd to me. Like, to me, it's like you could just take a look and I mean, that's not required. And it seems to me that
What's not required?
like you could take 2 minutes to find out if these are actually doctors. Like it seemed like a
True.
strange thing to like throw them off.
Well, true, but to counter that point, it's not the ZBA's responsibility under the law to go on a fact-finding mission. It's the petitioner's responsibility to establish the record. I will say in my litigation practice, if I have an expert medical witness, those reports are hand-signed and there's medical license numbers included in that. That's not an unreasonable thing. And if you have a neurologist or a psychologist, they must be familiar with that request. It's also a situation, I feel, that the meeting minutes layout, I mean, if you look at here, there's 5 reasons why this request is denied. It's almost a roadmap to fix it and come back. That never happened here. I mean, it's a simple phone call to the doctor's office, say, hey, could you put a wet signature and a license number on it and then resubmit it? That's a simple fix. There's nothing to suggest that the ZBA would not have heard this a second time had these issues with the record been resolved. In the same vein, could have easily provided more information regarding how the chickens are kept and maintained. What does the health look like of the chicken? Do they see a vet? How is the muck being disposed of? Are they inside? Are they outside? How much space do they really have? I mean, what we have is basically a map of the property with an X where the chicken coop is, but that's not a lot of information when you're talking about the care and keeping of chickens and the health of chickens, particularly when you look at the guidelines that are put forth by the Michigan Department of Agriculture. The last point I would like to make is that the standard of review for ZBA appeals is very clear in the Michigan court rules and in the corresponding case law. This is not a Fair Housing Act case. There's been no original action filed in federal court. I don't think that Mr. Carroll's counsel disputes that. And so we would just ask that the court review the ZBA's decision as well as the circuit court's decision under the applicable court rules, MCR 7.122G1 and the substantial evidence test. So if the court doesn't have any questions at this time, I would reserve the rest of my time for rebuttal.
Nothing.
Thank you. You have plenty of time for rebuttal. You're welcome.
Thank you. Good morning, Your Honors.
Good morning.
Please the court, Aaron Speck on behalf of Lester Carroll. Lester Carroll is on a death sentence with this disease. It's going to result in death. I think the medical evidence supports that. When Mr. Carroll was charged criminally, the city dismissed the case after I became involved. They then charged him civilly. I believe it was an effort to avoid a jury trial in front of the citizens of Taylor on this original criminal case. The civil case has been stayed pending the application that was filed with the ZBA. I would point out to the court that great deference should be given to the circuit court. There's case law I've quoted in my brief. As to the circuit court's review of the actual factual findings, and I would like to stress to the court that when the application was submitted, we know it was denied, and the board's first response was request vague. That's how they open it up. Well, if we take a look at the record, we do have a detailed drawing of the property that was submitted to the ZBA, fenced yard, a coop. We also have information that shows that this property, and it was formerly an agricultural situation. This is a situation where the city kind of grew up to the agriculture. Eventually, this one piece of property that my client owns was rezoned to light industrial and residential. There are no residences around this property at all. In fact, it's been presented that when this case was argued in the circuit court, that there was never even a complaint regarding the Carroll's property to anyone within the city ever regarding these chickens. But in terms of the great deference, I think should be given to the circuit court. We take a look at the request variance. It says request vague. There's nothing vague about it. The attached letter that is not commented on by Dr. Toledo, it's the third letter that is very significant. It talks about what the variance is for, the kind of animals, the type, the exact numbers, and even the individual names of the animals. That's the affinity, the relationship that Mr. Carroll has with these animals. That's what is so important to him. Pardon the expression, but there's kind of like a pecking order here with these chickens, and they all were significant to him. So the request was certainly not vague. I think this is a situation where the ZBA just didn't want to consider at all because there was chickens involved. So we're going to, what did they do? They took a look at the letters presented and said, oh, it's not signed. Well, yes, there was a stamped signature. It was on Henry Ford's letterhead. It's in the record. Then the second letter, it does have a signature, but there's no medical license. And then we have the third letter, which, as I've referenced, is hardly vague. It has everything you can possibly want to consider about Mr. Carroll's condition and the need and the reason for the variance. I don't understand how the zoning board can even use those two terms, quote unquote, request was vague. The medical evidence was overwhelming. And for the zoning board to not even comment on the letter that's presented, the third letter, we're just not even going to comment on it, is really shocks the conscience here when dealing with this. In terms of the health of the chickens, how the animals are maintained, there's a diagram showing how they're going to be kept. They've been kept on this property for years. This is nothing new. The health of the chickens, we're not talking about commerce. We're not talking about distributing eggs to the community. This is strictly for Mr. Carroll. Council points out, she says, well, she wants to use this term, well, they're just backyard chickens. No, they're more than backyard chickens. This is something very serious to a citizen of the city of Taylor and to his health. And to minimize it and say there's just backyard chickens is a way of just saying, well, let's just forget the legal arguments here. No, these are emotional support animals that are crucial to this man. I don't know if he's going to survive before
Here she's basing that on the timeline, right? Where at one point in time, they were not yet labeled officially as emotional support animals, but rather were kept in the backyard. And then steps were taken to get.
Correct. And I think in hindsight, maybe he should have started it sooner. But the point is, at the time that all this action began, he has these diagnoses ongoing. So it's not like some kind of afterthought where we're going to go manufacture. So this gentleman has a serious medical condition. I think he met his burden. I think the circuit court looked at it correctly and basically said, you want to send this back after this record? You call this vague? This is not vague. You just ignored the evidence. And I think the circuit court should be affirmed. I think the circuit court came to the right result. Very difficult case. We understand, but I think that Mr. Carroll met his burden. I think the letters that were submitted and the documentation as to the layout of the coop on the property, and the fact that we're talking about never having received a complaint about anyone in the city of Taylor, ever, by the city administration, anybody. And there's no neighbors next door. It's all industrial around this property. We're not talking about something that's going to affect the community, and nor has been any evidence that it has affected the community. So I think Mr. Carroll met his burden. I think the circuit court reviewed the factual findings correctly and just said, this is very, very troubling. And I think the court should simply affirm what the circuit court did. If the court has any questions, I'll be glad to answer those.
Judge? No, thank you. You may be seated.
Just very briefly in rebuttal and to close, Mr. Speck is asking the court to be deferential to the Wayne County Circuit Court's decision, but that's just not the standard of review. And in fact, the Wayne County Circuit Court is instructed by case law and by the Michigan court rules to be differential to the ZBA. It's not a de novo review when you get up to the circuit court. The court cannot just change the result because it does not agree with it. There has to be certain things that were wrong. And if the record is determined to not have been substantial material incompetent, the result per the Michigan court rules is not to simply reverse it, but to send it back down to the ZBA to allow that process to play out appropriately. And so we would ask that the court today vacate the Wayne County Circuit Court's order and reinstate the ZBA's decision denying Mr. Carroll's variance request. Thank you.
Thank you.
Thank you very much.
That case is submitted. Okay, we're going to call the next case. It's number 20, Homeowners Association of Northville Colony Estates versus Robert Schurig. And it's 11 o'clock, so everyone should be here.
Morning.
Good morning.
Joseph, good, nice to see you.
Nice
all.
to see you.
I've obviously submitted my brief, and so I'm going to just hit what I think maybe are the salient points on that, and then of course any questions that we may have.
Thank you.
By way of brief background, I represent Northville County Estates Homeowners Association. There's 317 homes in this particular organization, which is an LLC nonprofit. And as part of the charge and duties responsible for the homeowners association is to strictly enforce the building and use restrictions, which all homeowners receive notice on their deed, and which had been acknowledged by the appealees and the defendant on this matter as well at the time of purchase. That was in 2018. In September of 2022, the homeowner contracted with a landscaping company, for lack of a better word, to construct, which has been semantically argued different times depending on pleadings, but what we both admit is a structure. And under section 15 of the building and use restrictions, as is with many numerous home organizations in Michigan that I represent, they set forth a kind of a two-tier requirement to any structure.
No,
or building.
I understand all that, and Judge
Okay.
Allen went out, took a look at the gazebo and, did all those things. I think
Okay.
he lives out in Northville.
So skip ahead, okay,
Yes.
Skip ahead to litigation expenses.
okay,
Are they in excess of $750?
yes.
Okay. That's not a routine expense, is it?
Well, yes, as part of
It
it,
is? I would guess, you're a very fine attorney, Mr. Corroville, and I'm from out that way, so I recognize a lot of your work, and I don't recognize you personally by name. Seems to me that this is costing a lot more than $750.
yes.
And that's not something that should have been approved by 2/3 of the homeowners?
No, not in our opinion.
Not in your opinion.
Right. Well,
Why? That, in my opinion, I want to know why.
yes, because in the case law that's pointed out by the defendant, there was a particular case, Tuscany, I believe, that they pointed out, where there was another matter involving.
Well, I'm in a homeowners association in Plymouth. And if we're going to litigate something, I want to know how much it's going to cost and how much it's going to hit me in homeowner assessments, all those kind of things. That's a huge expense.
Right. So it's a budgeted item. It's in every
Yeah,
budget.
that's routine stuff.
Right. So it's an
This is
operating.
not this is not a routine operating. You don't anticipate litigation like this every year.
No, not like this, but if the standard one, the case laws, there's several authorities given to the HOA to obviously enforce their restrictions. So from time to time, as in this case, where the homeowner ignored his requirement to do a pre-admission and a pre-approval, litigation came as a result. So this is a budgeting, not a non-operating. It's an operating expense. Again, it's the bad of the homeowner, not the homeowners association. There was requests made to bring them to the table to try to get this resolved, and we were told to go get an attorney. We'll talk about it in court. And if we were left, or any homeowners association was left with the burden of which $750 was done over a flower dispute years and years ago. Granted, these need to be updated, so that's $750, but I would still argue this is an operating expense. Then they could never bring litigation. They can never enforce
Well, they could if they had the approval of 2/3 of the homeowners.
or they couldn't if everybody said, hey, regardless of the fact that we're required to do these things and it's the law, we're going to vote not to bring it.
Well, regardless of the fact, we went over and took a look at the gazebo. It's not that bad. I don't think we should litigate.
Okay?
There we go. So you're not going to get the approval and life goes on.
But that's not the venue of the individual homeowners to do. This is the
Well,
authority
the
vested in
venue
the.
or I guess it's the decision of the individual homeowners if they want to litigate, if they want to spend more than $750.
This is a volunteer board that they elect, that
Right.
people volunteer for.
I'm familiar with how those
Okay,
work.
so
yeah.
it's their
For
decision.
the life of me, I don't know why anyone wants to be on one of those boards, but my hat's off to them.
Yeah, well, Bob, one of the original residents, Bob's here. He's the treasurer.
I'm a member of two, and I have the same opinion on both of them. I don't know why anyone wants to. do
And
it.
I represent
I
several.
have an excuse. I have a ready-made excuse. I can't do that stuff.
Yeah, I represent several. So I understand all of those arguments. But again, it would pull the base out for the HOA ever to, and not only in this particular case does it not apply because it's an operating expense, as in all the other HOAs that I have, and distinct from
Well,
Tuscany.
there's an easy fix for this. Just go back and amend the bylaws.
Right.
There you go.
Well, that's not going to amend the bylaws moving forward.
Moving
kind of thing that
forward,
comes
yeah.
in. And every 10 years, we're discussing that already as a side note, because there's other issues that need to be, there's not allowed to be trucks parked overnight in the driveway and basketball nets in the driveway, because when they were drafted, those were things that people didn't want, which is kind of back
Well, I
along.
think in most subdivisions allow movable basketball nets, not the ones that are sunk into the concrete.
My point is that,
Yeah.
yes, it always has to be updated and ascertained based on current standards or likes or dislikes. But this particular vision, and it wasn't even considered by the court in rendering its decision as well, that we didn't meet that burden. I just think that not only was it not intended, distinct from Tuscany, that it would make the HOA ineffective if you could get somebody who's either popular or convincing or somebody doesn't care to continue to say, we're not going forward with litigation, especially since the burden should rest with the homeowners in this situation, because they didn't even do the bare minimum of pre-submitting the application and then getting approval, hopefully by working with
It was
HOA,
almost
then
like
there
the-
wouldn't have
It
been.
was almost like the chicken guy. We'll
Yeah.
seek permission afterwards.
Yeah, forgiveness, not permission. I don't know about the chicken guy, I only got a little bit of the argument made before you, but yeah, that's exactly what this is, because the whole purpose of that is when you submit your documents,
I understand totally. We understand all those things. and-
right, they wouldn't have brought litigation,
Yeah, you're right,
right? They
but
could,
it's here.
it could have been resolved and then we wouldn't have to do so. Not, we've built it. But their argument is, and the judge's argument, I should say, who kind of went off, and I'm just directing this towards you because you're engaging me, so I'll try to pan a little bit more, but that they cured it by subsequently sending in the documents after it was built, which makes no sense to me, because then why wouldn't everybody just do that? Why not just build it and then say, here's our documents to support it? It would vitiate the entire procedure that's not only with this HOA, but with every HOA that I represent. There's a number of unpublished decisions just cited in support of the same analysis as before here. It's not a new argument. It's not unique. It's if you're going to build something, in this case, a structure, come to us, submit the design, submit the plans. We'll look at it. If we have any concerns, wants, needs, we'll work with you to bring those into compliance in hopes of, getting the structure built, but not we're doing what we want to do and then come after the fact and say, oh, you didn't have the authorization to bring this lawsuit. And it's rewarding the.
Yeah,
bad.
either way, you could have had a lawsuit if they denied permission at the outset, the homeowner could have sued. So you're gonna have a lawsuit there.
But that's an if.
So I,
Who knows that we're going to deny it?
Oh, obvious, well, it seems to me you wouldn't be litigating it if you weren't gonna deny it.
so I was listening to the judge's
not
questions
true.
and now I'm looking at your bylaws. You don't have a definition for operating expenses, correct?
I don't have that with me. I have the building and use restrictions, but I'm assuming, I don't know if they do or not say that.
I can't.
No.
He's gonna say it's part of every budget. It's voted on. It was voted on by these particular defendants twice. While this litigation was pending, they were at the meeting and they voted to pass it, knowing the cost at that time.
Well,
And again, that
okay.
wasn't what was,
You've answered my questions anyway.
okay. That wasn't even part of the judge's decision.
Well, I know it wasn't, but it's something that we have to consider.
I understand. I'm just, do
Yeah.
you want me to go back?
I can see where Judge Allen was coming from, being in a homeowners association, all those kind of things. But that's not necessarily, we'll consider what he did, but we also have to consider some other.
I understand. Yeah, I'm not challenging that, obviously. But aside from the cure not being applicable in case law and obviously deeming that to be ineffective, he then replaced judicial review, which is in the exclusive decision-making of the homeowner itself.
You might be right on all those things. It's the $750 expenditure, I think, where you have your issues.
Well, it's an interesting point, Judge.
I don't know if you want me to continue on. You said you cut me to that chase, so I don't know if I need me to reiterate.
Oh,
that.
I said you answered my questions.
Okay. Should I just continue then from where I left off, or?
Yes.
Okay. So essentially, they bought the home, they knew of the restriction, they admitted it, they know it's a structure. Went through the point where we were told, we're not gonna, don't talk to us any further, talk to the attorney. So it was them that demanded the lawsuit, right? Instead of bringing it back, like in most cases they do, and try to negotiate the difference. And the judge on summary disposition with very little argument, I don't remember any, quite honestly, but there may have been some, said anything further, I'm ready to rule. And then kind of made his own decision, aside from the arguments that were set forth in a lot of the briefing up to that point, and saying that he was satisfied that although not submitting the documents as required by section 15 of the building and use restrictions, well settled, caused a cascade of issues that led us here today. That by them subsequently, after it was built, submitting those documents cured it. And so much of the brief is set forth on how that doesn't cure the requirement. And I've set the case law forth on why that is. Again, with my example being, well, then everybody would just do that. They would just build and then say, okay, after the fact, here's what you do. And then in terms of the approval itself in the bylaw, in the building and use restrictions, it says, which obviously run with the land, that if there's a call or a close call, then The grantor in this particular case, the bylaw or the homeowners association gets the final call on what's appropriate or not under the aesthetics provisions that set forth within. And the judge said he didn't like that and said that this particular structure, which I'll talk a little bit about the structure, is no different than any ones he sees across other HOAs in Plymouth or else that he goes. But
Well, he actually went to that subdivision, didn't he?
he did,
He took
yes.
a tour.
Right, we walked around and looked at it. And it's vastly different. Vastly different. One, it doesn't, the judge should not be comparing.
You included pictures in the record.
Right. It
Yeah.
shouldn't be his opinion over that of the HOA. The HOA's board has the exclusive opinion decision on whether it's aesthetically appropriate or not. But nonetheless, it's a structure. It's heavy foundation. There's columns, there's electrical, there's gas lines.
It's, I mean, I think it's a structure.
Right. Okay. So it was admitted to. So we're past that argument. So, so that's where we're at. So we don't think that the judge was correct in dismissing our motion that a cure to the requirement for them to submit. And then we also don't think that he can supplant judicial review in place of both under the business judgment rule and the authority set forth in the BURs of that of the board, which are decided that it would not meet with its approval. And the one line from the case law that I pulled because I liked it is that it's deed restriction, not deed suggestions. So that's up to them to decide it, not the judge. And I don't have anything further at this point. I
Jim?
appreciate the questions.
No, Judge, anything else?
Thank you.
Thank you so much for your
Thank
argument.
Yeah, rebuttal time.
Absolutely.
May it please the court, Lawrence Gadd on behalf of the defendants, Robert and Jennifer Schurig. I know that you've read everything and I'm gonna try to be as brief as I can. I think a very salient point here from a factual standpoint in this case, which differentiates it from almost every case that he cites. He cites a litany of unpublished opinions to whatever extent those carry weight with this panel, is that this board has never identified any particular aspect of this project that it found objectionable or that was in some way inconsistent with the rest of the subdivision. That request, and you'll see that in the letters that are attached as exhibits, the request was made multiple times to tell us what is wrong with this project. And the only thing they ever came up with is, we think you should have asked for permission first. And I will get to that issue a little bit later.
I mean, that's a valid point, right?
It is, well,
I mean,
I'm not going to concede that for reasons that I'll explain down
Okay.
the road, but
All
but that's the only thing. And so in all of these cases, you had clear violations of the deed restrictions. You had fences that were erected that were clearly against the bylaws or the deed restrictions. You had farm animals on one case. You had a facade in one case that was different than the 1,200 other homes in the development. In this particular case, there's nothing. This is a vindictive and very punitive lawsuit. And I think it's very apparent from the fact that the only thing they're upset about is, well, you didn't ask for permission. And they did submit, the plans and the specifications. It might have been after the fact, but once they did that, they never identified what was wrong with it. It was inspected by the city of Northville, which approved it. Testimony was taken. The testimony was unanimous by the board members. Anyone who was deposed in this case all said, this is beautiful. It adds to the value of the community. It adds to the value of that particular home. There's not a single person who testified that there was something wrong with this particular project, including the board members and the president of the board who was deposed. Everybody admitted, hey, this was really nice. And the judge, when he went out there, was completely befuddled as to why this was even in litigation.
I mean, I've been on panels where the panel felt like the law required entire houses to be torn down because they violated deed restrictions by upgrading them with providing things like plumbing and insulation. So how is this different? You'd mentioned that in your opening to us, that
Right.
you get to that. I'd like to hear it.
Sure. So negative covenants are strictly construed against the drafter, the homeowners association in this case, and any doubts are resolved in favor of free use of the property. And that's the Sampson case. Now, in this particular case, the provision that they're relying on is ambiguous. The judge ruled it was ambiguous, and it's ambiguous for other reasons as well. There's a patent ambiguity in the
You're talking
bylaw
about
itself.
section 15?
Section 15. The title talks about enclosures and other structures. This is not an enclosure. This is an unenclosed gazebo.
Yeah, we saw.
That then the text underneath it talks about structures and other structures. It is a patent ambiguity within the text of the BUR itself, which doesn't particularly give notice to the homeowner. And we point that out in our brief. But I think even more compelling than the patent ambiguity is there's latent ambiguities in the enforcement of this provision. In 2022, a year, just 1 year, not something in 1960 something or 70 something, in 2022, this board, the president of this board, in writing, said, we do not have jurisdiction over unenclosed gazebos. And we attach that as Exhibit E to our brief. If you looked around this project, there are gazebos everywhere, and that was also part of the record, and it's referenced in our brief. Gazebos that did not require permission from the homeowners board, and which they did not attempt to enforce any deed restrictions against any of those people. So this homeowner, or any homeowner, was not on notice, getting to your point about should they have asked for permission, that a gazebo, an unenclosed gazebo, would require permission from the homeowners association based on their past conduct, based on a vote of the board of directors in writing a year before.
But inconsistent enforcement isn't the same thing.
Well, it's clearly ambiguous because the board itself can't decide whether it covers gazebos or not. The text of the deed restriction is ambiguous on its face, and then enforcement of the deed restriction has been inconsistent. This board itself has determined it didn't have jurisdiction over gazebos. I think that's the very definition of ambiguity. Now they're saying you are required to seek permission. It is covered by the deed restriction. You have a past board or a board president a year before saying they don't have jurisdiction. So
And it said that in the meeting minutes?
So I'm not
Is that what
talking-
you
yeah,
said?
I mean,
I'm
that- no, it's
I
in
don't
a-
remember where that is.
it's attached as Exhibit E. And this is a email from the president of the board, Ray Gazebo. It says, Bob, thank you for continuing to champion your interpretation of the bylaws. I know that you're coming from a place of passion and a desire to support the betterment and continued evolution of our community. While I respect and appreciate your take on the matter, a vote was taken to determine if we even had jurisdiction here. From our individual, independent, and reasonable interpretation of the bylaws and restrictions, the determination was made that we do not.
That's in a vote, though,
That's,
that we have in the record? Or just the email?
well, the follow-up email says, in my opinion, the 3-2 board vote to approve the gazebo falls short in enforcement of the business and use restrictions. So anyways, this was the board itself in writing making a statement that we do not have jurisdiction over gazebos. So to the extent that there's ambiguities here, they have to be construed against the board. I don't think there was a requirement that these people submit for, or certainly they weren't on notice. If they looked around the community, nobody else had ever sought permission for a gazebo, nor had it been denied by the board or even considered by the board. If you looked at the deed restriction, you could read it either way, the very definition of ambiguity. It's not the homeowner's responsibility to write clear bylaws. These are two law-abiding police officers. They're not rule breakers by nature. If they felt they needed to seek permission, they would have. They just weren't on notice that they needed to for this particular project in their own backyard. You've already addressed the voting issue. Certainly, the bylaw in this case, or the BUR in this case regarding the voting is actually more inclusive than the Tuscany case because it's not just litigation expenses, it's all expenses. It's clearly not an operating expense. I believe this is the only litigation the Homeowners Association has ever had of this nature, certainly. So this was not an operating expense. When the president was asked, would you consider having a vote to see whether the people want to continue this litigation or proceed with the litigation, he said no. And the reason is this Homeowners Association clearly would not have approved this litigation. And the point of that provision is so that the members of the homeowners association aren't assessed or their funds depleted on something that they simply don't want to pursue. This isn't the board's money. This is everybody's money. And so while he can stand here and talk about the board this, the board that, they're spending everybody else's money. And so everybody else should
Has there
have a
been a
say.
special assessment on this yet?
I have no idea. I have no idea, but I can tell you this lawsuit's probably cost tens of thousands of dollars for this homeowners association, including this appeal. So, and the case that they cite, the unpublished case they cite, seems that all they cite, the Hills of Oakland case, there was no voting provision at all. And that's why the court ruled the way it did there. It wasn't a Tuscany situation. In that case, there was no requirement to vote at all in that case. So it's really not applicable. I mean, the court did exactly what it should have done in that case with no voting requirement. So unless you have any questions,
No, we don't. Thank you.
oh, one other point I did want to make is there was an explanation that was provided in Exhibit 31 that they submitted, as well as an explanation regarding this email and this gazebo, which was not part of the record. And so I do object to any reference to that.
Thank you.
I've been the attorney for the HOA from day one, and as part of my responsibilities as that HOA attorney, I go to these board meetings as well. So Mr. Gadd, this will be the first time we've met. I can tell that he's talked to somebody in the firm that's got some knowledge of the arguments, but they're not the facts in this case. So I've only got a few. This is important to know. This is a common area where this gazebo was placed, and it was raised by a neighbor 2 doors down, saying this, what was offered to us as a patio is now a structure partially blocking my view. Ironically, where it's placed in relation to the homeowner's backyard is in front of a row of bushes that separates their view of that common area, not the area that's open, so they can look and receive the benefit of looking into this park, which is the whole point of having an HOA, and the whole point of them having these no fences and the building and use restrictions. So they themselves decided that it was an obstruction, and they didn't want to point it out their back window. It's not the township. I mean, it's not the city of Northville, as council said, it's the township, often confused, 2 different municipalities. And the fact that they required an ordinance to be able to build this structure, which we talked to the building ordinance director, said, yes, this is definitely a structure in my definition. They were required to do that. The plans they submitted were written essentially, for lack of a better word, on a previous quote, rudely drawn out. We want the gazebo here. We want some pavers over here. And they had Reliable out, who was the person that constructed it.
I just want to clarify, they built this gazebo on their own property, not on the commons area.
Right
correct?
up abutting, yes.
Abutting, okay, because I thought
Yes.
you
Which is-
misspoke.
Yeah, you
misspoke
did
and you
too.
said it
You
was
did
on the
say that.
commons area.
No, I said the whole place is, there's a park.
I understand there's a commons area,
Correct.
but I thought you said this gazebo.
If I
was
did,
built
I
on
was
the ground.
mistaken.
Yeah,
That would
thank you.
change.
I was just about to look that up.
Oh,
Thank
no,
would
you.
change
that would have
the
been my
equation.
first argument.
Yeah.
Yeah. They built it up, not on their property. But it's telling as to where it was placed, because it's the least obstructive place they could put it in their particular view.
Now I understand your point.
Yes, okay.
Thank you.
It's the city, not the township. I'm sorry, the township, not the city of Northville. The board that select provisions of the deposition that I handled, where they may have said that they thought that it was nice or that they had some opinion on the value of it, is not what they voted to do. They said this is clearly not part of the building and use restrictions. And when they came, because of the faulty or lack of specificity in the plans itself, they had to do a site review. And when they came and looked at it, they said, well, this is far more than a patio. This is a structure, and it's already built. So that same board that may have said, honestly, that it looks nice, but it's a structure in an area that we don't like, and it's a permanence that you've already built, and so we're denying it. So cherry pick comments after the fact that they had already voted as a board to deny it doesn't carry any weight. They admitted, again, during their deposition that they had notice. I think the word that they used was oversight. Oh, it was an oversight. It was an oversight. And even I understand that it's an oversight, because a lot of people come before the court on HOAs not realizing that there's restrictions within those BURs and bylaws that they subsequently say, oh, I didn't know. But they had notice. They had notice that they admitted when they took the deed. It's not ambiguous. I think we talked about that previously. structure is a structure, so they're trying to work around this. So they're saying they don't have notice of it. They didn't even know they had to. And now they're saying, well, even if we did have notice of it, it doesn't say gazebo because we made that word up 5 minutes ago. The jurisdiction is a cherry picked, again, email that I provided because I disclosed all my electronically stored information to them to say, here's all the discussions that went on about this and whatever discovery request they had. And it was in the middle of a discussion of important note of somebody that did apply for a permit to have a structure, a gazebo from Costco, an older woman to tap up against her house. Someone she's outside sitting on the porch, non-permanent, all the things that we would have liked this one to be, not a permanently foundation structure detached from the house itself in the corner abutting it. And they subsequently agreed to approve that gazebo. So it's not that they don't have jurisdiction. They retained jurisdiction. They made a decision on it because she submitted plans like the defendant should have done in this particular case, and they didn't. And then the police officer, them being police officers, is offered in every argument. I have my own suspicions why. But I think it does dawn on me as to go to the situation where if you've got a couple of young police officers walking around an old neighborhood, gathering votes to say, I want to kill this litigation that people are bringing against me. I need to get your vote to do so. Could be another problem in addressing getting the general.
You know what?
Could
That's
be
not
intimidating.
before us.
All right, you asked me about the
Yeah,
two-third
I know,
votes.
but I mean, police officer or not, carries no weight with the court.
Yeah,
I agree.
All right,
All right, it was mentioned.
right.
it was mentioned in passing.
Okay. Well, it's been mentioned at every stage of this litigation.
Well, I don't know. If that's in the record, we can go look it up, but I don't think that should be made into a mountain.
I don't even remember it if it was in the record.
Maybe it's my own sensitivity then of having.
Could be.
Yeah. And these are two of 317 people, 317 votes, 317 homes in here, right? So this decision, it's not even two, it's one, because there's two people who live there, one vote. That their decision to bypass the building and use restrictions, what they contracted for, a covenant, restrictive covenant, that it's clear that it's a structure, and that they built it in ignorance of all of those things, should supersede the remaining 316 people who live there that want this common area to remain how it was, or at the very least.
Well, did they take a vote on that? They want the common area to remain as it was? I mean,
was already built.
that's a supposition. But anyway, I'm not going to belabor the point.
Yeah,
We get what your argument
I
is.
think the HOA's got that authority.
Right.
And then my client said he spent a very reasonable rate of it. I think the amount of money's paid to me, but they've been able to bring it within their budget, so there's been no special assessment today. So part of the
Anything
regular
else?
budget of what they normally budgeted.
Nothing else?
So there's a portion of the regular budget that's dedicated to litigation.
Yes.
What is it? What's the term that they use for the litigation that it's dedicated to? Part of its operating expenditures. It's in the
This
budget.
isn't
Yeah.
the operating
Yeah,
expenditure,
it's,
correct.
it's included in that.
And we had
Yeah,
these.
but
two-
the
Correct.
parties agree that this
Yes.
is more than $750, this issue we're talking about.
Right.
Okay.
And I mentioned earlier that they themselves appeared and voted on the passage of that after raising that argument.
All right, thank you very
Thank
much.
you.
That case is submitted and we're moving on. Thank you so much. Are you good? Do you need a break? Okay, all right, we're gonna take about a 10-minute break and then we will be back for the next case. Thank you very much. We'll call the next case. It's number 21. It's 370-994, Robert Davis versus City of Highland Park. Well, we only have one side, oh, you do? Okay.
Who's checked in? Those are all appellees. Is Mr. Austin or Mr. Patterson checked in? Those are the only two that are endorsed to the appellant.
Well, they're not endorsed.
Oh, no, they're not endorsed. Excuse me. Thank you, Mr. Helmkamp. Okay. No one's endorsed from the appellant side, so I guess.
What do you want me to do? Okay, all right, go ahead.
Good morning. May it please the court. Robert Abb from Van Overbeck, Michaud, and Timoney, representing the Wayne County Employees Retirement System and Retirement Commission. Thank you for your time today. I sat here and I've heard the panel. I have complete confidence. You're very familiar with our briefs, so I will be brief as well. Simply put, the trial court correctly dismissed the plaintiff's complaint, correctly finding that he lacked standing to bring any claims against the retirement system. He submitted a vague request under the Michigan Freedom of Information Act to explain the retirement benefits of Mr. Helmkamp. After reviewing that request and its record with counsel, the retirement system produced the most responsive records it could, plan documents and the summary of the plan description that describe his retirement benefits. Summary plan document is, quote, a publication explaining the benefits of a particular welfare benefits plan. It's Sprague versus General Motors Corporation. The trial court correctly held that the retirement system, quote, did indeed produce any and all written documentation related to the explanation of retirement benefits available to Alan Helmkamp, just as plaintiff requested.
I guess you could go online to look at those benefits just like anybody else, right?
Yes, Your Honor.
On our
In fact,
website?
and that's required under the statute, and that's what we did. We provided him a link directly to all of those documents.
Let me ask you a quick question, because I was kind of comparing Mr. Helmkamp's retirement to my own in terms of, there's a third-party vendor that takes care, at least the state of Michigan. Is there a third-party vendor that takes care of Wayne County in terms of, giving an explanation of what you have in your account and all those kind of things?
Yes, Your Honor, absolutely. They have a third-party record keeper, Empower Retirement. Thank you, Your Honor. Additionally, the court noted that, the documentation provided to Mr. Davis, quote, not what plaintiff was looking for. He had the right to submit a subsequent, more specific FOIA request in order to more clearly identify the documentation he was seeking. Instead, Mr. Davis filed this lawsuit without the right to do so under MCL 15.2401B. Simply put, again, Your Honor, Mr. Davis received the records he requested. They may not have been what he wanted, but that's not actionable under the FOIA, and the trial court properly dismissed the complaint. We respectfully ask this court to affirm the trial court's order and opinion. I appreciate the court's time this morning, and I'm prepared to answer any questions.
Any more questions? Nope, thank you very much.
Thank you very much. Appreciate it.
Good afternoon.
Good afternoon.
Barely. I am Alan Helmkamp, and I'm Assistant Wayne County Commission Counsel. I'd also like to introduce, I'm Assistant Counsel. Our Commission Counsel is Felicia Johnson, who's here present today as well. Again, just very briefly, we think the FOIA issues have been thoroughly briefed. I would just make two quick points if I could. The request by Mr. Davis was specifically for ordinance number 8313, which concerned retention of counsel by our body, the County Commission. When we go back into our minutes, we find that item number 8313 was not an ordinance. It was a resolution for the funding of police officers, and that is Appendix 15. So on that basis and the erroneous reference to Ordinance 8313 in the case Mr. Davis cites notwithstanding, we denied the request because the record does not exist.
Did you deny, or is that the Wayne County Clerk's?
The Wayne County Commission denied it because if it had existed, it would have been with us. And the request was for an ordinance, any amendments passed by the Wayne County Commission. So we were the appropriate constituent entity of our municipal government to respond on behalf of both ourselves and the clerk. And that was by communication and agreement.
I know in the case, there's a case where the two entities were FOIA'd, and one entity responded with the document, and that satisfied both entities' requirement.
Right, and
Here's
that's,
a little bit different. Both entities, neither one has the statute that's sought, but only one responded. The Wayne County Clerk's Office responded. The Wayne County Board of Commissioners didn't.
right.
So-
And so the case you're referring to, I think, Judge Reardon, is the Densmore case. And then one of its progeny out of this court, the Washtenaw County case specifically, was a denial. And there, because it didn't exist, and there
Right.
was no need to have a duplicative separate denial of the non-existent of a record. So anyways, we believe on that basis, the court's rulings on the FOIA issues were correct. With the court's indulgence, I would like to briefly address the issue of whether the Wayne County Clerk must act as the clerk to the county commission. Now, certainly this,
Just to get back to what he said and Dunsmore, with Judge Reardon was highlighting that in Dunsmore, the document was actually provided by one entity and not the other. Here, neither entity has it. So is that a distinction without a difference, or?
no, again, the Washtenaw County case, I could find you the whole site, spoke to that. And as
Then you
Judge,
briefed the Washtenaw County case?
yeah. You just bear with me one second.
Densmore DEN? Yeah,
Yeah.
okay. It's on page
Yeah, it
2.
was after the Densmore case, right? We had, I think, 3 cases from this court, which are progeny of Densmore.
Are they in your brief? the
Yes,
three
they are.
cases?
Because if the denial says, there aren't these records within the possession of the commission, doesn't that leave open whether another public entity has documents that are responsive?
Well, theoretically it could, but then that gets into our argument about what constitutes a public record. And a public record under the statute is one that is a writing prepared, owned, used, and in the possession of the public body in the performance of a function.
But if the Board
So
of
the clerk-
Commissioners don't have it, wouldn't it be just as easy? The Wayne County Clerk already said, I don't have it. And would it be as simple as remanding it back down the Wayne County Board of Commissioners saying, we don't have it either? Boom, we're done. Because the Wayne County Clerk's Office can't speak for the Wayne County Board of Commissioners.
So let's then go to the crux of what this is all about. The law is clear and our procedure on our website is clear that a request to our municipal entity has to come to the county's FOIA coordinator. Then the determination is made by that individual, what constituent, what component unit of our entity would be the one most appropriate to have that document and to respond.
Right.
That decision is made internally. What this gentleman has done is he sends the same duplicative request to 2 or more component units of our government in what I would characterize as a game of gotcha. He loves the fact that he got one response. He wants 2 responses, 3 responses, 4 responses, and it makes no sense.
Well,
And it doesn't serve the purpose of the statute.
Might not make sense, but I mean, he did ask for the documents from the Wayne County Board of Commissioners, and it's as simple as the Wayne County, the WCBC or what have you, saying we don't have it.
We answered on behalf of the clerk as well. I mean, he has filed dozens. We get hundreds, maybe thousands.
You're preaching to the choir. Believe me.
Efficiencies,
How is that, you said you answered on behalf of the clerk, where is that indicated?
Well, it was in the letter.
The clerk answered on behalf of the clerk.
Right. But then it says, but the exact language from Johnson is it only pertains to the records within the possession of the commission.
That was the characterization of the request.
All right, well, we'll work our way through it.
Okay. So I was about to then briefly speak to the issue of the county clerk as clerk of the commission. This panel could decide not to reach the issue because you could see it for what it is. He did not have standing in Davis 1 and Davis 2 to try to have the county clerk imposed as our clerk, and he did not.
I was on one of those Davis.
You affirmed that ruling by
Yes,
Judge Smith.
exactly, and I thought that was kind of underhanded to ask for it again, personally.
Well, but there are 2 other cases in this court that also address that issue that are pending.
I said personally because I already
Right.
voted.
Right. So to get around that, he frames this as a FOIA issue. He wants to bring in MCL 4611J, which says the county clerk has to certify that ordinance. He wants to put that double certification on the FOIA statute. It's insufficient for him that the FOIA officer of the commission certified the response to the FOIA. He wants the clerk to do so. But the reason for that is to get to the issue which has been underlying all of these lawsuits, is the county clerk, the clerk of the county commission. And so as to that, if the court does want to get to it, which I don't believe that it needs to, the matter is governed by both statute and by county charter. We are a creature of the Constitution, Article 7, Section 2, as well as the Charter Counties Act. We have specific authority to become a charter county. We have specific authority in the Charter Counties Act to transfer duties of officers, particularly including the clerk, to other departments. And so that's what our charter did in 3.115, parens 10. The commission appoints its own clerk. And we've done that since 1983, always without objection until these lawsuits started in 2023. Never a problem. But now it's a problem, apparently. So the Charter County Act authorizes expressly what we've done. And then finally, maybe a word about the MOU. And again, Judge Reardon might remember this. There was some side discussion in Davis 1. It was not outcome determinative there. It was left for another case expressly. The problem with the way the MOU got interpreted there was it was specifically without prejudice agreement. We tried to stave off litigation by memorializing what the arrangement was with the clerk. I mean, so we appoint. If the clerk also wanted to deputize, we had no objection. We specifically said, we have our law, you have your law. Without prejudice, we're coming up with this arrangement. And so nowhere did we ever acknowledge that the clerk had the right to be our clerk or to appoint a deputy. And so I think that was a mischaracterization. So then, without questions, unless the court has some questions, that's what I had.
Nothing.
Nope, thank you.
Okay, thank you very much for your time.
All right, thank you very much. That case is submitted. Moving along to number 22. That's 375547. Will Coxon versus Garrett.
Coxon is remote.
Yeah, I don't see them yet. Miss Will Coxon, are you there? Did she check in?
But she's talking.
Good morning, Your Honor.
There you are. We can hear you now. Thank you. Okay. So would you like to reserve some time for rebuttal, ma'am?
Yes, I would, Your Honor. Thank you.
All right, you may begin.
Dieta Wilcoxon, Dieta Wilcoxon improper, Your Honor.
All right, you're good to begin, ma'am.
This case really is fraught with red herrings, and one of them is necessary on the part of the county clerk, and one is necessary on the part of the city clerk in order to have received a favorable ruling from the trial court. The county clerk argues that there is no case for controversy, that this case is moot, and that MCR 2.11C8 is applicable. None of those are actual facts. The county clerk argues, as well as the city clerk, that the genesis of this case is the disqualification of appellant, which occurred in August of 2024. The complaint, however, was filed in May of 2024. The ballot access was for November 2024. So factually speaking and temporally speaking, it is impossible for the case to have originated with the disqualification of appellant. The fact that MCR 2.116C8 requires a pleading for its assessment destroys the argument on the part of the county clerk. There's only one pleading in the case on the part of appellant, and that is the complaint. So without the complaint, there is no pleading for an MCR 2.116C8 motion to attach to. The county clerk argues that the Michigan Administrative Code is applicable to this case. She argues that she has the ability, according to her admission, to go back some 20 years and collect fines and fees. That's the only authority that's cited by the county clerk. I think this case is controlled rather by this court's ruling in Reed Pratt, which is a 2022 case. Reed Pratt holds that Ayers, who was before the court, had no requirement to report to the county clerk because the county clerk failed to provide notice under MCL 169.216 subsection 6, which indicates that the official who is required by the state, in this case the county clerk, to report fines and fees must do so within a 4-day period. The statute in question uses the terms must and shall. This court in Reed Pratt concluded that the fact that Ayers was not notified within 4 days and did not have the 9-day provision pursuant to Section 7 to respond, that she was not required under the statute to file the 7 purported outstanding statements that were due according to the county clerk. The same facts apply in this case. The only difference is that the county clerk in this instance is attempting to go back some 20 years to collect fines and fees. The administrative code is not applicable. The statute is clear on its face that notice is to be required. Reed Pratt indicates how that notice is to be applied to facts, and the facts of Reed Pratt are consistent with the facts in the case at bar. The city clerk argues another red herring, which also dates back to the actual filing of the complaint, which is not at issue in this case. The only question that was raised as it relates to the city clerk was whether or not MCL 169.560B allows for an iteration of a candidate's name to be used, one, on the ballot. There was no question relative to how the name appeared on the ballot in the case at bar. The only question was, does the statute extend to that same iteration chosen by a candidate to be released to the press and the public in the event that they seek the identification of candidates? It may be a case of first impression as to whether or not the statute extends that far. That's the only question before this panel, and which was before the trial court as it relates to the city clerk. The alternative pleading done in the trial court included arguments relative to the Michigan Campaign Finance Act. In the event that the court refused to accept that, appellant argued in opposition to the Michigan Administrative Code. Appellant also argued equitable defenses, latches, waiver in fact, of which the trial court dismissed but our Supreme Court has held that waivers, in fact, under clause are to be honored in the state of Michigan. It is not necessary that there be a writing, which the trial court required. There was also an argument relative to estoppel. None of the arguments that were made, whether they were constitutional in terms of due process and there not being a reasonable opportunity to present objections to any of the requests that the county clerk made, arguments relative to the Equal Protection Clause, another red herring argument on the part of the county indicating that the traditional arguments under the Equal Protection Clause were not made. The Michigan Constitution, needless to say, at Article 1, Section 2 indicates that Michigan residents also have a right to have their political rights upheld in the state of Michigan and that they will not be discriminated in the exercise of those rights, which is what was argued by appellant below. The county clerk argues that there is a need for waivers and dissolutions to be decided only by the Secretary of State. The statute is quite clear at MCL 169.215-19D that the same responsibilities that are imposed on the Secretary of State are imposed on each county clerk throughout the state of Michigan. The county clerk did not give any notice that she was not processing waivers and dissolution requests. She did not give any notice in terms of there being outstanding fees. She did not give any notice that she was exercising an arbitrary power to disqualify appellant from the ballot. There was absolutely no notice as to any of those. So they do not pass muster under the state of Michigan's due process clause, notice being a prerequisite if any act in the state of Michigan is to be accorded finality. Those are the basic arguments that I wanted to make to the court. The county clerk seems to argue that the administrative code can be used retroactively. Our Supreme Court in Pohusky has already decided that in the state of Michigan, statutes are not retroactive. They are prospective in nature, unless there's an indication in the statute that it is to have retroactive effect, which is not the case as it relates to the Michigan Administrative Code. Does the panel have any questions of me?
I think you covered it very well. Thank you so much. There's no questions for you, but you have plenty of time for rebuttal.
Thank you so much. Appreciate it.
Yep. Counsel?
Good afternoon, Your Honors, and may it please the court. Vincenzo Convertino on behalf of defendants County Clerk Kathy Garrett and Gil Flowers. Plaintiff appellant originally filed her complaint on May 20th, 2024, seeking an emergency declaratory judgment and alleged violations of state election law and due process rights against defendant County Clerk Kathy Garrett and Gil Flowers. Appellant's suit derives from her disqualification from appearing on the November 2024 election ballot as a candidate for the U.S. House of Representatives. The clerk's office disqualified appellant from the ballot because appellant had and still has multiple outstanding and unpaid campaign finance fees, which has now spanned over multiple election cycles. Ultimately, the trial court granted defendant appellee's motion for summary disposition because no actual controversy existed, rendering appellant's claims as moot, and because it would simply be impossible for any court to grant appellant the relief that she is seeking. The November 2024 election cycle has long since passed. Appellees rely on our brief submitted to the court, and I would be happy to take any questions that this court may have at this time. Thank you.
No questions. Thank you very much.
Thank you so much, Your Honor.
Ms. Wilcoxon, you have a little bit of time if you have some rebuttal.
I do. As to the disqualification that was just argued as to outstanding fees, the disqualification has absolutely no authority in law. The county clerk has not cited any. When the county clerk cites the Michigan Administrative Code, again, they admit in their papers that are before this court that their authority came into being in December of 2022. At that time, these quote unquote outstanding fees were approximately 20 years old. The county clerk had not collected, and the discrepancy in terms of whether or not there is a right to any fees, I think was put to rest again by Reed Pratt. The argument on the part of the county clerk is that the 2024 filing of this complaint somehow is the only issue that was before the trial court. It is not. The questions before the trial court were, how is a candidate in the county of Wayne supposed to have waivers and dissolutions decided when the county clerk of the largest county in this state is of the opinion that she has no responsibility and the quote unquote burden, according to the county clerk, rests with the Secretary of State. How is a candidate supposed to have those decisions made? There is also the issue of whether or not notice is applicable in the county of Wayne. According to the county clerk, it is not. This is not a stagnant issue before the court. The issues were ongoing. They were made in a complaint that was filed in May. The disqualification did not occur until August, so the complaint could not refer back to, or refer forward rather, to a disqualification which occurred months later. The argument on the part of the county clerk, again, is a red herring. The complaint was articulated with a number of provisions asking for decisions that had nothing to do with the 2024 election cycle. At paragraph 11, appellant asked about the provisions relative to dissolutions, late fees, altering campaign finance reports that have been submitted to the county clerk so that a candidate was required to report when they had attempted to check a box to avoid reporting. As it relates to the issue of equal protection, as appellant pointed out in appellant's papers, Beverly Kendall Walker was told by the county clerk, go away, come back another day. She came back another day. The county clerk went on record fighting for her, saying that she qualified for the record despite the fact that she missed the opportunity to file necessary paperwork.
So I think you're going a little bit beyond, the reply is just to address anything that he brought up before the court. I think you're going a little bit beyond that.
I apologize, Your Honor. Let me stay on point. The point of the matter is a complaint filed in May of 2024 with a disqualification coming in August of 2024 for ballot access of November of 2024 cannot factually support an MCR 2.116C8 motion, which according to our courts is only to be assessed, analyzed based on a pleading. Michigan at MCR 2.110 indicates that a motion is not a pleading. It indicates that a pleading is a complaint, cross-complaint, counter-complaint, third-party complaint, an answer to a complaint, cross-complaint, counter-complaint, or third-party complaint, or a reply to an answer. So
okay, thank you so much. Your time is up.
Thank you, Your Honor.
All right, thank you. The case is submitted. The next case we're calling is 23-378-363 De. 'DeHaven versus De. 'DeHaven. We have one party. We have Mr. Lee.
Yes, Your Honor.
Mr. Lee, you want to say a little bit about your case?
Yes,
endorsed for oral argument?
May it please the court, Barney Weitzman here representing appellant Muller, Brittany DeHaven.
Excuse
who
me,
is sole-
you're the appellee? Are
I
you
mean,
the
I'm sorry, what did I say? I said apple, I'm so sorry.
Are you
I
the,
100% the appellee.
sit down then. Do you
Well, I'm the
apologize?
only one that's endorsed for oral
Okay,
argument.
sorry. Oh, sorry about that. I should
No, it's okay.
I should have kept my mouth shut.
No, you're okay.
No,
Thank you
no,
for
no, wait,
correcting me.
no, I'm sorry. I think we were a little confused because you have to ask to sit up here if you're not endorsed. So thanks.
First of all, thank you for correcting me, okay? Thank you.
No,
Just
thank you for
nervousness.
correcting me.
No, it's okay. I want to do something that no one else has done, and I've not done it myself, but because my planned remarks are going to be very short, I just wonder if right now anyone on the panel has any questions for me as attorney for appellee.
I have none.
Great.
No,
Okay.
we're familiar with the case.
Okay.
That should tell you something.
Sorry?
That should tell you something.
I appreciate that. In any event, so I represent mother appellee Brittany DeHaven. She's got sole legal and physical custody of the now 10-year-old child. I struggled with whether I even wanted to be here today in light of the papers that have been filed. I was a little troubled by Mr. DeHaven's reply. And so I thought I would be here with regard to that. There are two motions that were filed, one by mother to limit Mr. DeHaven's parenting time, which was brought at the behest of the child's individual counselor. The second was a motion filed by Mr. DeHaven through his last lawyer, okay, arguing for a modification of custody and parenting time based on the report of a family counselor, okay, who is a different counselor than the child's individual counselor. My client's motion was voluntarily dismissed after the trial court dismissed father's motion. Father's motion was dismissed because my client declined to waive the privilege, asserted her privilege for herself and the child. My client, again, has sole legal and physical custody. The trial court honored that, asked Mr. DeHaven, you know, how do we get around that? Gave him couldn't be addressed. And so the court determined that there was no basis for father's motion to go forward and granted our motion to strike and suppress. Father's reply, the part in father's reply that bugged me and caused me to be here was that father seemed to indicate that he had other witnesses. Okay, well, that would suggest that other witnesses might be able to testify to something that was in his motion. His motion, as I indicated, which was drafted by his then lawyer, Philip Sturtz, who's a good lawyer, was completely devoted to the findings, the alleged findings and report of the family counselor, nothing else, okay? So if you redact everything in his motion that relates to the family counselor, because my client asserts her privilege, the child's privilege, the family counseling privilege, you have nothing. These 4 pages are going to be blank. There's nothing there. Father did not have any, because by the time of the October 21st hearing, father was in pro per, okay, having discharged Mr. Sturtz. He did not have any witnesses subpoenaed. He had to get subpoenas from the court. He did not have any witnesses. He had not requested any subpoenas. It was only 3 days after the judge dismissed his motion that he then, sought some subpoenas from the court. And arguably, those subpoenas could have been for mother's motion, but mother dismissed her motion after the trial court dismissed father's motion. So any argument about the record being imbalanced is just nonsense, because there basically was no record and nothing imbalanced, and father continues to exercise
the parenting time set forth in the judgment of divorce. None, as I indicated, I'm not going to belabor, none of the authorities cited by father in his brief or to the trial judge would warrant a waiver of the privilege. The trial judge.
I think you have a pretty strong argument there. There's no waiver of the privilege.
Correct. And the trial judge dealt with this both on the record and in her original response, but also in her response to the motion for
Like
reconsideration.
I said, I think you have a pretty strong argument.
I think I should leave the podium. Thanks, Judge. If anybody
Tell
has
you
any
what to
questions.
do.
What's that?
I can't tell you what to do.
That's okay. I get it. If there's any questions, I'll pass.
Fine.
Okay.
Nope, that case is submitted. Thank you very much.
Thank you very much.
All right. Next case, number 24, that's Hazelton v. Hazelton. And we have one person endorsed for oral argument. The other party contacted the court and let us know that they were waiving oral argument today. And I don't see.
Hi, Judge. This is Stephanie in the clerk's office.
Oh, okay.
It looks like they both waived.
Oh, thank you. All right, so that case is submitted on the briefs. Thank you for that update. Our last case for today is number 25. That's 376074 Henry Terrell Evans Terrell Minors, and that case is submitted. And that concludes our case call for today, and court is adjourned.